Hello and welcome to the first day of the grand jury proceeding. We are here in a room that has been specially built for this purpose to hear witnesses and experts with regard to what's happened in the corona crisis. And we are connected with an international group of lawyers. And to begin, I give the floor to Attorney at Law Aina Garner from the United States of America.
Anna is muted.
I think Anna is on mute. So.
Anna, you must unmute yourself.
Away. All right. Now I'm unmuted. Let me find my document, please. All right. Whoops. Here we are. Okay. Sorry. Okay. Can you hear me now?
Yes.
All right. Thank you, Vivian. It is my honor and pleasure to participate in this international grand jury investigation, an enactment of a criminal grand jury against some of the perpetrators who, in a worldwide criminal collaboration, committed crimes against humanity on the entire world's population in the form of a planned pandemic called COVID-19. We, a group of international lawyers and a judge, are conducting criminal investigation modeled after the United States grand jury proceedings. This grand jury investigation serves as a model legal proceeding to present to a jury consisting of the citizens of the world all available evidence of COVID-19 crimes against humanity to date against leaders, organizers, instigators, and accomplices who aided, abetted, or actively participated in the formulation and execution of a common plan for a pandemic. Crimes to be investigated include all acts performed or omitted by a person in pursuance of a common design to commit crimes against humanity, and all such criminal acts condemned in the various communities of jurors around the world. This investigation is of the people, by the people, and for the people, and shall be referred to as the People's Court of Public Opinion. Having been unable to find a court to hear the actual evidence in the current system's courts of law, we are undertaking this proceeding outside of the current system and based on natural law. This, in turn, is founded on the firm belief that every person can easily distinguish between good and evil and between right and wrong. This proceeding may be one of the most important events outside of the courts that will be done this year. We, as a group of international attorneys, will present real evidence from real experts, such as scientists, historians, doctors, as well as victims. There are no actors in this presentation, only real people who desire to bring justice to the world, and we need your help. The reason for the enactment of a grand jury process is because our world is at a critical stage in humanity, which will depend on the awakening of all people to reverse a course which could forever alter the way we live as free humans. We must reverse the trajectory of this course now, and portraying a grand jury investigation is the fastest way we know to bring the evidence to the world's public court, you, the people. In the United States, only district attorneys or attorneys general of the various states are allowed to bring such criminal proceedings. But since no one has done so in the United States, we come forward to present the evidence to you in a form modeled after this type of judicial proceeding, which is common in the United States. We base this model on the American criminal grand jury. Typically, the grand jury determines whether the evidence is sufficient to return a criminal indictment against one or more accused. It's conducted behind closed doors, and neither the accused nor his attorney is present in this type of proceeding. However, we're doing this process in front of full view of the court of public opinion, you, the people. The purpose of this investigation is to reveal the evidence which could be used in this type of proceeding in your jurisdiction. We invite you to join us in open transparency using real evidence, real attorneys, a real judge, and real expert witnesses that could be presented in an actual criminal grand jury proceeding in the United States courts. The success story of this country was written by people who trusted in a constitutional governance for the people. Our forefathers shouldered epic challenges in our history on the foundation of our Constitution. It was this Constitution and its recognition of natural rights and freedoms that released free-spirited human beings from the yoke of the British Crown. Therefore, and recognizing the urgency, we will be asking you, the court of public opinion, to review the presented evidence in order to reclaim our rights and freedoms granted to every person in this country and the world at the end of this proceeding.
Thank you, Mrs. Garner. I would like to turn to Judge Rui Fonseca y Castro, who presides this proceeding. Mr. Fonseca.
Good afternoon. The legitimacy of the court of public opinion based on the natural law. During the last 2 years, we have witnessed the dizzying collapse of the democratic rule of law. In the name of an idea of common good, which has never been endorsed, the most fundamental rights and freedoms have been taken from us. And we can already feel the approach of a gigantic wave of victims. Justice systems, once strongholds of fundamental rights and freedoms, no longer fulfill their duties. That is, there are no longer judges in Berlin. Shall we wait, doing nothing, until we are completely annihilated, or rather we assume our responsibilities as members of our communities? It is our rights, and above all, our duty to the people and to the future generations to resist oppression and tyranny. The natural law, immanent to the human being, regardless of its positivation, gives us the sacred right of resistance to oppression. If constitutions are the source of positivated freedom, fundamental rights and freedoms, natural law is its original source. Natural law confers legitimacy to the people to defend fundamental rights and freedoms before a state that has become tyrannical. It's clear now the failure of national and international justice systems to protect people from the tyranny that has taken hold. Therefore, it's in the natural law, an unwritten law inherent to the human condition, that this court of the public opinion finds its legitimacy to initiate the legal proceedings that will begin today. The court is open. Thank you.
Thank you for this introduction, Judge Fonseca y Castro. I would like to give the floor now to Attorney at Law Diana Pollard-Sachs from the United States of America.
Hello, my name is Dina Pollard-Sachs, and for the past 22 years, I've been a law professor, constitutional scholar, and civil rights activist and litigator. I'm here today to discuss the derivation of our Liberty Clause, which goes back to natural law, and to explain why the COVID-19 vaccines are all unconstitutional based upon our history's jurisprudence. On the 4th of July, 1776, Our founding fathers signed the Declaration of Independence. And here's what they said. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. In 1891, our Supreme Court, in a case called Botsford, explained that medical liberty is inalienable and one of the most cherished rights we can ever have. They said, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. The right to one's person may be said to be a right of complete immunity, to be let alone. In 1914, Justice Cardozo, who later became a United States Supreme Court justice, put it this way: every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. These same exact concepts and verbatim statements by our court have been reiterated over the decades. In 1990, for example, in a case called Cruzan versus Director, Missouri Department of Health, the Supreme Court basically held that each individual has a right to reject medical treatment. That goes back to the English common law. And here's what Justice Brennan said in the Cruzan case. Anglo-American law starts with the premise of thoroughgoing self-determination. It follows that each man is considered to be the master of his own body, and he may, if he be of sound mind, expressly prohibit the performance of life-saving surgery or other medical treatment. How is it then that our governments are pushing a medical treatment on us without consent, not real consent? They are coercing our people to take a vaccine that's experimental in nature upon threat of their livelihoods, their homes, and their education. Well, our government's relying on a case called Jacobson versus Massachusetts. So I'm going to explain the case and explain why it actually supports our side, that we get to choose medicine and medical treatments for our bodies. The case does not support the vaccine manufacturers and does not support vaccine mandates. In 1902, during a smallpox pandemic that killed hundreds of millions of people internationally, the state of Massachusetts passed a law. And the law said that each person must be vaccinated for smallpox or pay a $5 fine. That's exactly what the law said. It was an either-or law giving people the option to pay a $5 fine if they don't want to get vaccinated. Well, Mr. Jacobson believed that his liberty interest protected him both from the vaccination and from paying the $5 fine. So he went all the way to the U.S. Supreme Court after paying the $5 fine, and he wanted his money back. And the Supreme Court looked at the medical evidence. The smallpox vaccine had been in use for 100 years. It was being used all over the world with a great deal of efficacy, and it was quelling one of the worst pandemics in the history of the world. After reviewing the medical evidence carefully, after making findings concerning the efficacy and safety of the vaccine and the need for the smallpox vaccine, the court decided that Mr. Jacobson did not get his $5 back. Now keep in mind also, Mr. Jacobson believed he had a liberty interest to run around town and be seen out all over town without being vaccinated. So he sort of flaunted the fact that he wasn't vaccinated because he believed he had the right to be out and about without the medical treatment he did not want. And so the court's opinion was based on all of these facts. And these facts do not support COVID mandates today. In fact, one of the last things the court said in Jacobson versus Massachusetts, and I quote, "We now decide only that the statute covers the present case and that nothing clearly appears that would justify this court in holding it to be unconstitutional and inoperative in its application to the plaintiff, Mr. Jacobson." There are several reasons why Jacobson does not support the vaccine mandates of today concerning the coronavirus. First, there's an enormous difference concerning the public risks involved. The smallpox pandemic was killing up to 60% of people in villages when the smallpox came through. Anywhere from 20 to 60% of people were dying with an overall death rate of about 30%. At some periods, over 90% of babies who were exposed to smallpox were dying. Now compare that to COVID-19 that kills a tiny fraction of 1% of people. The public risk is not even close. The second thing is the COVID-19 vaccines are not really vaccines at all. Unlike the vaccines throughout history, which stopped infection and stopped transmission, these vaccines do neither. These are experimental vaccines. They haven't been around for 100 years. They haven't been tried and tested. And our people are being subjected to an experimental vaccine when none of us really know what the long-term effects are going to be. And finally, the law in Jacobson versus Massachusetts gave an option for the people to pay $5. Today, that would be just under $150. Compare that to people losing their livelihoods, all that they've worked for, their homes and their college education, because they won't submit to an experimental vaccine. There is simply no comparison. Jacobson versus Massachusetts does not support the vaccine manufacturers or the vaccine mandates. So some of you may be wondering then, why haven't the COVID vaccine mandates been declared unconstitutional fully? Well, some of them have been, but there's one that withstood the Supreme Court scrutiny on January 13th, 2022. So I want to explain that. First of all, the healthcare worker vaccine mandate arose from the taxing and spending clause of the U.S. Constitution found in Article 1, Section 8. Congress has historically been given great latitude to attach strings to federal monies. So you take the sour with the sweet. And if you want federal monies, you have to submit to the conditions by Congress. Throughout history, Congress has been allowed to put conditions on the receipt of Medicare and Medicare funding, and specifically has authorized conditions to limit the transmission of communicable diseases. Still, the opinion was 5-4, with only 5 justices agreeing that the vaccine mandate for healthcare workers passed the original test to see whether or not the court would stop the enforcement of the vaccine mandate. But the real question is, as Justice Thomas indicated, why wasn't the efficacy and safety of the vaccine considered? It was not considered. And Justice Thomas made that very clear in his dissent, joined by 3 other justices. Well, the reason that the vaccine's efficacy and safety was not considered is because the issue was not before the court. Of the 22 states who challenged the healthcare vaccine mandate, no state claimed that the mandate violated the Liberty Clause. The Liberty Clause is where we find our medical freedoms. Throughout history, the Liberty Clause is the clause used to protect us against unwanted medical procedures and even to allow us to demand medical procedures that we want. So you will see behind me a picture of the United States Supreme Court House. I have faith that when our justices are presented with the medical facts concerning the efficacy of the vaccine, the need for the vaccine, and the way our governments are bullying and coercing people to take the vaccine against their desire, the court will uphold our liberty rights, and they will declare all of the vaccines unconstitutional. Later today, and in the days that follow, you'll be hearing from a number of medical professionals describing why this vaccine is nothing like the vaccines of the past. So I encourage you to stay tuned in, and thank you for watching.
Thank you, Mrs. Pollard-Sachs, for this opening statement of yours. I would now like to give the floor to Dr. Rainer Föhmich, attorney at law in Germany.